All right, Sai, it is 12 o'clock, so we can go ahead and get started. I'll open it up and welcome everyone to our monthly webinar hosted by the Asian American Chamber of Commerce, and Proposal Helper is sponsoring it this month. The topic, of course, is a burning question that everybody has: joint ventures and facility security clearances, especially with CIOSP4 on the horizon here. Lots and lots of questions that keep coming up over that. And this is not limited to CIOSP4. So if you have questions very specific to CIOSP4, I just want to caution you, this webinar is all about general joint ventures, facility security clearances, and how all that works. So we welcome you on behalf of the Asian American Chamber of Commerce. If you're not already a member, we highly encourage that you join. You can also sponsor their webinars, and then you get a talking spot like I do to talk about Proposal Helper. We provide bid management, entire business development, and proposal management services across the nation and now going global. If you'd like proposal support, please reach out to us. We also encourage you again to please join the Asian American Chamber of Commerce. Quick disclaimer before I turn it over to why you are all here and want to hear Sai and not me. This webinar is for informational purposes only. Nothing said or provided during this webinar should be deemed to be legal opinion or legal advice. I will say this webinar is being recorded. It will first go out to the chamber members, and then eventually all participants will receive a copy of the slides and the recording. It will just take a little bit longer. The Asian American Chamber of Commerce members receive everything first. So with that, let me switch over to Sai, your presentation, and then hand it over to you. And just a reminder to participants, if you would like to network with each other, please put your information in the chat box. If you have questions for the speaker, please put them in the Q&A box. I'm only monitoring the Q&A box at the moment. So thank you. Sai, over to you.
Thanks, Reena. Hey, everybody. Glad to be here. So I guess just to start introductions, my name is Sai Alba. I'm a partner with our government contracts group at PilieroMazza. We represent a number of small, mid-sized federal contractors and some large guys as well, and a whole host of things. I know the next slide is a little bit just about the firm generally, but a lot of our clients are federal contractors, but we do everything from government contracts to labor and employment matters, litigation matters, a lot of M&A activity, things of that nature. So that's me. Now, I wanted to start, I guess we can go to kind of the basics slide and really go through sort of what these are. I'll do this relatively quickly. But when you go through and you say, well, what is an Fcl? Well, it's a facility clearance. It's issued by the Defense Counterintelligence Security Agency. It used to be DSS, changed a few years ago. I know a number of the documentation you might see out there that's still actually good documentation still uses the DSS logo because it was issued prior to the name change. Don't get confused. That's all the same thing. And the rules haven't really changed that substantially. So a lot of that information is still good. There's three types of Fcls, just like there's really three major types of personal security clearances. It's top secret, secret, and confidential. That's really it. I know people can get like TSSCI and all those kind of things and different types of Q clearances and things like that. But when you're talking about an Fcl, there's these three types of clearances. The applicable laws that really are important here that we're going to walk through is the National Security Industrial Procedures Manual, the NISPOM, which I'm sure a lot of people have heard of. You got Executive Order 12-829, which is simply the executive order from the 90s that created the National Security Industrial Procedures Program. And then you've got other various DoD regulations, and then the Committee on Foreign Investment in the United States. And one of the things you'll notice as we go through is that really DCSA is focused on foreign investment, foreign control, foreign issues. A lot of people, when they're dealing with joint ventures, or even in most of the clients I see, don't really have to deal with that specific issue, but that's really the focus of what DCSA is all about. And so when you're going through these things, think of it in that lens. So first, I guess on the next slide, we're dealing with the National Industrial Security Program, right? It's an old program at this point. It was established in 1993. It's kind of scary that was so long ago, but it was established in 1993, and it's between the federal government and industry to really make sure that industry protects classified information, and this acknowledgement that a lot of private industry, not just the real big guys anymore, at least in the 90s, are really dealing with classified information. It's not just your Boeings, it's not just your Lockheeds. It's a whole bunch of people who are helping the government. And so there had to be something in there to make sure that things were uniform and were controlled, and to make sure things didn't leak outside of these companies. And as I said before, kind of going on to the next slide, DCSA is really the one who controls this stuff. So the contractor, or in the case of a joint venture, the joint venture will really interface primarily with a DCSA field office throughout the entire Fcl process. A lot of times what we'll recommend is that if the majority member, or let's say a protege, if it's a mentor protege, or the small business, is the one who, if they already have a clearance, is the one who really takes the lead and talks to their DCSA rep to prep them. I think no matter if a joint venture or not, I always recommend being in close contact with your DCSA rep and running things by them, because if anyone who's ever looked at the NISPOM, you'll notice that the NISPOM is incredibly vague, right? It's not like the regulations you might be used to if you're a small business, and there's a whole bunch of SBA regulations, there's a whole bunch of case law interpreting those regulations. The NISPOM is not like that. The NISPOM is very general, and it really just gives high-level procedures. And when it comes down to how a particular fact pattern is going to be analyzed and treated by DCSA, it's that individual person. If you have a clearance already, you're going to have a rep, and that rep is the person you got to talk to and walk through earlier in the process if possible than later, so that they're aware of everything, especially given what's going on right now with the new SBA rule and joint ventures, which we'll get into a little bit later. Again, their primary focus is on foreign investment and control issues, which a lot of times isn't a key issue for a joint venture, or even for a lot of small or mid-sized companies. They tend not to have a bunch of foreign investment or control. A lot of the owners are US citizens, and so it's not a major issue, especially for small business programs. You have to be a US citizen in most cases. So the real thing for DCSA and the JV context or small business context is usually a focus on who's got control over the company. Do those people have the actual personal facility clearances that are necessary? That said, kind of going on to the next slide, there can still be CFIUS concerns. There's this Committee on Foreign Investments in the United States. And so if you've got an issue where you're going after a large contract, I had one client who had this, where they were forming a joint venture to go after a very large procurement where they were the incumbent. And there were concerns because this was so large. It had to do with a pretty critical program inside the federal government. And there actually were CFIUS concerns in that case because of the mentor's ownership. The mentor was purchased by a venture capital group that had a lot of foreign funding. And so there was concern there as to what was going on. And we had to kind of go through a few hoops, and it really delayed the process a bit. So make sure that you understand who your team members are, what their control schemes are. If they already have a clearance, great. You probably don't have to worry about that. I think you can assume that they're already following the proper procedures and things like that. But if there is an issue, or especially if there's certain control by certain countries, like, I mean, you can probably think of them, like China, Iran, Russia, certain countries that could be more of an issue than if it's ownership and control by like Canadian, right? Then there's not as much of an issue there. You can firewall that person and potentially set up other board members, and the DCSA folks shouldn't have a major issue with that. Kind of closing out the basic issues, the next slide is kind of on Fcl violations. And so if there is some issue that comes up, or if you've done things inappropriately, you haven't talked to your DCSA rep and walked them through things, you can lose your Fcl, which is probably going to turn into losing your contracts. You can be suspended or debarred if things are bad enough. And then the government can also seek damages or criminal penalties. So what we're talking about here is pretty serious. It's one of the issues where the government controls things very tightly. And that applies to joint ventures just like it does to anyone else. And more importantly, if you're in a joint venture and each member has a clearance, let's say, and somebody violates it, the joint venture can be held accountable for that. And I'll get into sort of how that works in a little bit. But you can suffer the same sorts of damages even if you're in a joint venture. So you still have to be careful. Going on to the sort of application process, I know this is sort of the precursor to specifically joint venture stuff. When you look at Fcl eligibility, what you're talking about when you're talking about a facility clearance is the entity, right? So even if you have the majority member and the minority member who have clearances, put the new SBA rule aside for a minute. The entity that you're talking about is the joint venture. And so the joint venture itself, certainly prior to the SBA rule change and most likely after, which again we'll get into, the JV itself is going to have its own clearance because it is its own entity. You need an Fcl anytime you or your people could be handling classified information. Certainly, if you are handling classified information inside of your facility, if you have a SCIF or something like that, you're going to need an Fcl before you even have that. So that's absolutely an issue. Most companies that I see, though, don't have SCIFs or don't hold classified information on premises. So it's not as onerous, but they still need the facility clearance if their people are operating on cleared contracts. The owners who are in control, and certainly some of the board members, like the chairman of the board, like the president or CEO, the top officers, will have to have a PCL, that's a personal security clearance, that's the same as the Fcl level. And in order to get an Fcl for a joint venture or anyone else, you have to either be sponsored by the government or a prime contractor. You have to have some sort of need, which is the validation of the need for access. You can't just say, hey, I'm potentially eligible, can I have a clearance? You actually have to have the need for it, which in the JV context is what tends to create the issue, because SBA, especially if it's a small business procurement, SBA wants to have your joint venture agreement be ready to go right before you bid. And there's some case law in the fall that suggests that, well, the JV agreement can get thrown out if you're protested and you can be found ineligible. If the JV agreement doesn't match your proposal closely enough, if it's too different. So you get in the situation where to apply for the Fcl, a lot of times the DCSA rep will want to see the agreements and the documentation for the JV. The parties from a business perspective will want to have all that buttoned up early in the process before they really get into the bidding too much. But then SBA wants all that revised prior to the bid to make sure that you've hit all the contract specific issues in the JV agreement. And so it's somewhat of a balancing act to make sure you're providing things to DCSA early enough so they can start the process, whereas you're amending it later. And I always recommend working with your DCSA rep. Again, I can't stress that enough, and communicating through the process to say, hey, we'll get you the revised documentation, but there's really nothing material. We just want you to have it. We're a good partner, so that you've met the SBA rules, general eligibility rules, and what DCSA likes to see when you're talking about joint ventures. And again, the SBA rule tried to clear that up, but I'll get into that in a second. So going on to kind of the clearance process, once the sponsor sends a request to DCSA, DCSA begins to review everything. They're probably going to conduct a phone or will conduct a phone survey to the contractor to kind of test your knowledge. And when you're talking about the joint venture, the way it used to be done is that you had to kind of populate the joint venture. Even though SBA rule said it can't be populated, there's a carve out that says it can be populated with administrative personnel. So you have to populate the joint venture with maybe a couple KMPs, key management personnel, the FSO, things like that, so that you have some people up there so that when DCSA is checking on you and going through the process, that your personnel know their stuff. If you already have a clearance, great. If you're the protege, let's say, in a mentor protege joint venture and you have a clearance, that's fantastic. You can go and put your FSO and your folks up into the joint venture, so they're sort of co-employed with the JV and yourself. And then all of this process that's here on the slide, DCSA can work with your folks and talk to your folks about putting all that together. And they already have the knowledge, they already have the expertise. Your FSO can be an FSO for multiple companies, but at some point, DCSA is going to question whether that person can actually fulfill their duties. And if you are a company who has a facility clearance already, and that you have a SCIF or you are holding classified information at a physical location that's not a government site, the government is going to look more carefully at whether your FSO can actually be an FSO for multiple firms. Now, I haven't seen it be a major issue with joint ventures, but when companies who have SCIFs and have high level, say a top secret information being held at a physical location they control, I have seen DSA question whether the FSO can really do that job and at the same time do that for other entities or subsidiaries and things like that, because it takes a lot of extra time and effort and they are the responsible person for that work. If you don't have any sort of clearance yet or have any FSO, we highly recommend that, let's say you're the protege and your mentor has it, but you don't. Aside from the new SBA rule, which has kind of been shot down by DCSA and DOD, which is why I'm going through all this. Another thing you need to do, and this is the way it used to be done and still should be, is that your mentor could, in theory, give you some sort of subcontract on some other contract that they have that's a cleared contract to give you as the protege that need, and then they can sponsor you. Once they sponsor you as part of the mentor protege process, and I recommend putting this in your mentor protege agreement, they can work with you on making sure your people understand things. They can show you the handbooks, the guides, the checklists, provide that to you, help train your rep so that when they get the call, when they talk through the information, your FSO already understands all of these processes, and that should make it easier. One caveat is I have seen DCSA, in some cases, some reps, question whether an affiliate can sponsor another affiliate. And I have seen that come up in at least one case where it was a mentor protege. I don't think that's really appropriate. There's nothing in the NISPOM that directly states that a mentor cannot sponsor a protege. But I have seen that come up one time. So just a caveat to be aware of and to kind of work through the DCSA folks and think about that ahead of time so that you can explain some of these issues to them. Also, of course, if you have foreign owners, then you really need to think about it ahead of time because there's a number of processes that have to be put in place and those people need to be excluded. Kind of going on to the next slide. These are just the documents that they're going to ask from you, at least these documents. So make sure you have all of these things ready to go. In particular, this third bullet, board resolutions excluding lenders, owners, and employees who do not have a clearance. You have to have exclusion resolutions drafted before DCSA is going to grant you an FCL if you have owners, in particular, owners and board members or officers who do not have the requisite level of personal security clearance. If they don't, you're going to have resolutions drafted, and they're pretty simplistic. They're actually in the handbook, the DSS handbook, so it still uses the DSS moniker. In that handbook, it has the exclusion resolution text in it. And you just need to make sure that you have those drafted and approved appropriately based on your corporate documents to make sure that anyone who doesn't have the clearance cannot have any influence over the cleared contracts or the cleared work. That's a fine line. So what does that really mean? What about someone who has the ability to sort of, it's like cancel a 401k or change the 401k provider, so now it increases fees or something like that? Or what about cutting wages? Well, if you're cutting the wages of the cleared personnel, that can negatively impact the cleared contracts. So if the person doing that is the CFO, let's say, they don't have a clearance, arguably they shouldn't be able to make those determinations that could negatively impact the cleared contracts that you have. That should come from someone who has the clearance, like the CEO. If you have a board of directors, the chairman of the board generally cannot be excluded. That person has to have the requisite clearance. Your highest level officer, like your president or CEO, has to have the requisite clearance. Generally, DCSA will not allow you to exclude those individuals. Same thing when you're in a joint venture. If you push people into the joint venture, those people who are sitting there for purposes of getting your clearance should be clear, have the requisite level of clearance, your FSO and whoever else you put up in there. Otherwise, there's going to be an issue. Obviously, the FSO has to have the clearance all the time because they're in charge of all of that. DCSA can also ask you for additional information. Kind of going on to the next slide. A lot of the stuff they'll ask you really dig down in is if you do have foreign ownership. They'll ask you to explain it, identify it, and anyone who owns more than 5% of the company, they're going to ask for other information.
So, Sai, let me interrupt you here for a second. Folks, if you're putting questions in based on what Sai has just said, please make sure you provide full context of your question. We are going to take and monitor questions at the end. So if you put half-assed question in there, unfortunately, we won't know what you were referring to during his conversation. So please type complete questions because we do want this to be helpful to all of you. Go ahead, Sai.
Yeah, and some of this stuff I was going to go through, some of the questions I was going to hit later. So we'll just kind of answer them. When it comes to things like dual citizenship here, generally speaking, I would work with the DCSA rep pretty carefully on that. And I think they're going to want to know what sort of relations you have. Like this question about the UK is usually less of an issue, and NATO countries generally are usually less of an issue. But that being said, I had cases where someone was a dual citizen, and because of the level of clearance and what was at issue, the DCSA rep actually required that person to either reject this citizenship of the foreign country or be excluded. So that can happen. So I would say work pretty carefully with the DCSA rep. And as far as who your rep is, that person will be assigned to you once you go through the clearance process. So once you're sponsored, and let's say your mentor or someone sponsors you, at that point in time, you'll be told who your rep is going to be, and you'll start interfacing with the DCSA field office and that individual. And that's who you will work with going forward. All right, so going on to quickly talk about the PCLs, the personal clearances. So the PCL has to be obtained during the Fcl process, right? For certain people, like the facility security officer and your key management personnel. So if you don't have those already, that's going to be part of this process, and that will slow down the Fcl because the Fcl can get processed a lot faster than the PCLs can. Because what they're going to do, you can get interim clearance, but a lot of times, depending on what's going on, they can take a while. I've had some that a few months into the process, we started getting questions because an individual, I guess, had an affair that they had disclosed. Their spouse knew about it, but then apparently there was another affair that the spouse didn't know about. And that's the kind of risk issue that when that crops up, it can be a problem. Another major issue people should be aware of, I'm getting a ton of questions right now about investing in like marijuana. Marijuana is still a class 1 drug at the federal level, regardless of what your state says. And so generally speaking, if you're investing in it, there could be other issues with government contractors. But if you're a government contractor and you're investing in it or you're using it or whatever, that, especially if you're going for an Fcl or PCL, that can be a major issue. There was just guidance issued by DOD saying we don't care what the state says. Even if it's legal, if you invest in marijuana stocks, then that's investing in no different than, like, I don't know, investing in Pablo Escobar's cocaine operation, because cocaine and marijuana are both class 1 drugs. So you need to just be aware of that and be careful of that. That's just one thing that keeps cropping up. I guess, let me go through some of the questions here. Do not currently have a facility clearance, but we have a client who wants to add clearances to the current contract secret level. I've asked the client to sponsor and they agreed. Then I asked them to initiate the DD-254. Beyond that, is there anything else my company needs to do proactively? Not directly. So that's what you need to do is you talk to your sponsor. They would go through the DD-254 process. Once that happens and everything gets submitted through, you'll be contacted by DCSA, and then that's where you'll start to know, okay, who's the office who's I'm dealing with, who's the rep I'm dealing with, and go through those sorts of processes. Acquiring Fcl, I'll get into that. As far as this, there's a question about JVs being unpopulated, and I think that's in relation to, do I need to put some KMPs up into the JV? Do I need to put the FSO? The answer is yes. So the SBA rules say it cannot be populated, but the DCS rule says it has to have an FSO and it has to have KMPs. So those are in direct conflict with one another. Again, the SBA rule tried to change things, but that's where the problem has started to crop up. And I'll get into that, I think, in a second. Can a member of a JV sponsor the JV for the Fcl? Yes, that's generally the way that it works, is that the JV gets sponsored by a member who has, and again, put aside the SBA rule, the JV is sponsored by one or both of the members who have a clearance, and it goes through that process. Usually, in most cases, in most RFPs, the small business or the managing member should have that first, and then use that to sponsor the joint venture. If the managing member does not have it, again, putting aside the SBA rule for a second, if the managing member does not have it, then generally DCSA will likely not approve the JV for its clearance. So you kind of have to go through a tiered process of having the minority member sponsor the majority member, and then once that's completed, get the JV going. So it can be a bit of a drawn out process. Let's see. Can't one of the parties JV sponsor with a subcontract to the JV? Yes. So the other way to do it is if the JV gets a subcontract, you could sponsor them, but that's the exact example that I saw DCSA have an issue with, and they refused to move forward with it. I haven't seen that happen across the board, but some DCSA folks will not allow, because they see it as that affiliate sponsorship that they have problems with. And I'm not sure why certain offices have the issue, certain field offices, and certain don't, but it's just something to be aware of. That if you need to talk to your DCSA rep and lay out for them, hey, we think it'd be easiest if the mentor sponsors me or sponsors the JV, or if I'm the protege and I have it, I'm going to give a subcontract to the JV for sponsorship. that's my plan because we have a lot of great work we're going to go after as a joint venture. DCSA rep, do you have a problem with that? It's perfectly fine under the NISPOM. It's not improper. See what they say, talk them through it, make sure they're aware of it. Because what you don't want to do is send your rep like a DD-254, work through that process, and then they reject it, or they don't want to hear about it, or they're annoyed that they were kept out of the loop. I've seen that kind of thing happen pretty often. So the number one rule when you're dealing with Fcls is talk to your rep, communicate with your rep, walk through things with your rep, make sure they're aware of it, explain it to them. If you think there's something wrong with it like that, explain to them why. Don't just ask the question necessarily. Give them the story of, hey, this is fine, this is what we're doing, we look forward to working with you, or whatever, something like that, instead of straight asking. Oh, as far as populating the joint venture, people are asking about, the SBA rule says you can populate it with administrative personnel. Generally, though, SBA has seen to work with DCSA that the FSO and certain KMPs just being co-employed are still just admin personnel because they're not the billing people. They're not the direct bills on the work. That's where you get into problems under the SBA rules. Can the JV receive sponsored from one of the partners? Yeah, we went through that process. They can put you on the contract if you have. Do you have to be a prime of that contract under the mentor protege program? I'm not sure what of the protege. Do you have to be the protege? No. So if the mentor has a clearance, right, and the protege does not have a clearance, and you have a joint venture, in theory, the mentor could sponsor the JV as a separate entity. But if the protege doesn't have it, I think, like I said before, the DCSA folks could take issue with that. And also, it's possible, even under the SBA's new rule, that there could be an issue with that as well. So I think, let me go through, we'll go down to the slide specifically on JVs and FCLs. I think some of these questions will get answered as we kind of walk through the new rule, what it really means, how it's really being implemented, and how some of this stuff is really fitting together. So historically speaking, if you go down a couple more slides, historically speaking, some agencies have refused to award contracts requiring an STL to a JV that if the JV itself doesn't have an FCL. And that's even if both members of the joint venture, or all members, say it's 10, everybody has a top secret FCL, but the JV doesn't. Agencies have generally said, no, I'm not going to award that contract. And in addition to that, DCSA has said, no, the JV does not have a clearance just because all the members do. The JV has to have its own clearance. Because of that issue, though, SBA looked at it and saw it as a major impediment. So I'm sure, as everyone knows, they issued a new regulation recently stating that, look, the JV, that's small business joint venture, can be awarded contracts requiring an FCL so long as either the JV or the lead small business partner has the requisite level of security clearance. But if the cleared portion of the contract is ancillary or not the quote unquote principal purpose, which is something SBA, that phrase SBA loves to use, if it's ancillary or not the principal purpose of the procurement, then the non-lead JV member, which again, if it's a mentor protege, could be a large business, that company can possess the requisite FCL and the JV can still be awarded the contract. You just have to be careful then how you're divvying up the work share so that all the cleared stuff that's ancillary is going directly to this non-controlling member, while you over here, if you're the protege, let's say, are doing all the non-cleared work. You can do that, but obviously you got to be very careful how that's flowing. And you also can't prohibit, in that kind of circumstance, the minority partner from talking to the government, because obviously anything that has to do with cleared work, you can't be a part of. You have to be completely excluded from any of it, from seeing it, from talking about it, from knowing about it, all of that. And that obviously gets a little weird about how you're managing things. But the SBA rule allowed for that. Whereas generally, the small business partner or the protege or whatever has to have it themselves if the main parts of the contract or the entire contract requires a clearance. So that's sort of how that breaks down. And then again, if only the lead small business partner has the Fcl, then obviously you're responsible for keeping all the records relating to the cleared work. Just like if the minority member is the only one, they are responsible for it. So then getting into the next stuff on JVs and staffing, you have to know that, yes, SBA rules have said, look, the JV can't hire individuals to perform work on contracts, but DCSA says you have to put people there in order to get a clearance. So it's only those admin folks, the FSO, maybe some of the KMPs. You do not put people who are billable up into the JV or you're going to have problems with SBA. And again, those are generally considered administrative personnel. Now, what's really important, and I think the sort of elephant in the room, is that SBA's rules that we just walked through on that prior slide have essentially been rejected by DOD and DCSA. DOD and DCSA have said until guidance comes out from DOD as to how we're going to work this or whether we're even going to accept the SBA rules, we're not following them. We actually just filed a protest on behalf of a client a couple days ago, challenging the government's refusal to follow the SBA's new rule. The government in that case took corrective action, and who knows what that corrective action is going to be. I'm actually not a part of that particular protest, but perhaps they're going to loosen it and they're going to accept it. We don't know. So we thought that was going to be a case to sort of push this issue to a head. There might be other cases floating around out there that I'm not yet aware of. But as of right now, the new rule is not being followed by DCSA. That's why all the stuff I went through earlier about how you actually get a clearance is something you still need to follow and is still of critical importance. So when your joint venture is looking to get cleared, it's still going to have to get, as of right now, still going to have to get independently cleared, which means you're going to have to go through one of the two processes of either trying to give it a subcontract, the entity itself, trying to give it a subcontract to get cleared. You're going to have to go through the process of moving certain KMPs in the FSO up into the joint venture and have them co-employed. In most cases, what I haven't seen yet is how DCA deals with this idea of the ancillary work. So the SBA rule part that I think DCSA might still accept is if there's ancillary work that requires a clearance, but it's not the primary work, can it be that the minority member has the clearance and that the minority member sponsors the joint venture without having the majority member have its own Fcl? It's possible that that could work. I have not seen that go through yet. I haven't seen how DCA is going to deal with that under the new rule, but I could see that as being a sort of compromise where DCSA says, all right, we get it. We don't agree that the SBA maybe had authority to issue this regulation because it deals with clearances. That's DOD and DCSA. That's not an SBA question. So we're going to ignore it. I think that's their argument. We're going to ignore it because SBA arguably had no congressional authority to issue those regulations. Again, I think that's what they're saying. And so because of that, it's null and void. But as a compromise, we'll let the JV get its own clearance if they're sponsored either through a subcontract or otherwise by the minority member, so long as you have a plan in place to ensure that there is no leakage between the minority member and the majority member. I think that's possible. In most cases, though, I still think, unfortunately, they're going to require the majority member and probably all members to have the requisite clearance in order for DCSA to approve the joint venture's clearance itself. So for now, I don't think the SBA's new rule is really going to change that much in how the government is going to look at things with joint ventures and how DCSA in particular. But my understanding is that SBA is working sort of behind the scenes with the folks at DoD and the folks at DCSA after that guidance was put out to try to see how they can work together to get DCSA and DoD to accept how this process is supposed to work, to ensure that small businesses have more opportunity to go after these types of contracts, because they understand right now it's difficult and it's time consuming, especially if only the mentor has it and the project doesn't. Then there's two levels of sponsorship that have to occur, and it can be pretty difficult. There's a question about getting the protege cleared is meaningless if the JV itself is not cleared. Are you saying that getting the protege cleared will help the JV itself? Yes, that's exactly what I'm saying. So a lot of times DCSA will want to see definitely the majority member, the protege, let's say, but most likely both companies. And unless you have both companies in there doing it, then they're likely not going to approve the clearance for the joint venture. Let's see, can you explain the process of getting the JV itself cleared again? I think I just kind of walked through that. So you get it either by, you can give the JV a subcontract. Again, I've seen that not work in one case where DCSA rejected that, saying it was an affiliate sponsorship, which was odd because I've done it a million other times, or I've seen it a million other times without a problem. So it's possible that they're taking a tighter stance on that. But usually you give them a subcontract, or you give the mentor can give the protege a subcontract, something like that, that actually gives them a need. You go through that process and then work through your DCSA rep to get the JV cleared. That's the most common way it's done, the most common way I've seen it done. Also, though, if you're going to be sponsored, I've seen this happen before too, if you're going to get a contract, let's say you're getting a sole source contract. Okay, you're an 8A company or something else, you're getting a sole source. You can get sponsored, the JV can get sponsored directly from the government agency, and that they can usually help you push that process through faster. That's usually occurred in cases, though, where both the protege and the mentor, I think all cases I've seen, both the protege and the mentor already had their own Fcl, and then that's how the JV got sponsored. Let's see. Can a JV with a current Fcl sponsor a follow-on JV for their Fcl? So I don't see a problem with that either, so long as the DCSA rep is willing to go through it. That's almost, I think that the one office, which I wish I could remember which field office it was, but I can't at the moment. The one field office I saw reject that, it was not that particular scenario, it was just an affiliate relationship. And I think if you have one joint venture that has the same members and another joint venture that has the same members, that office might have, or people that have that view could take issue with that. At the same time, though, I think that joint venture, the only cleared contracts the members have is through the JV. I don't think it's impossible that you could sponsor that other JV through a subcontract from one JV to another JV. And if both JVs are similarly situated, arguably you could also treat them as similarly situated entities. So the one JV could subcontract its 51 or part of its 51% requisite work, if you're a small business, to the other small business joint venture. There hasn't been super clear guidance on whether JVs can be considered similarly situated companies. I think so. I mean, I've done things like that before, and so I think you could do that. It's not 100% guaranteed to work just because of the way. I just don't know of any case on it yet that's been fully adjudicated, but I'm pretty sure that we'd have a very good argument if you did that. and then it's up to GCSA to allow for the sponsorship there. So I think you could do that. Is it allowable? If this is allowable, oh, the first question, what's the first question? The mentor protege program is designed for large businesses to provide mutually beneficial developmental assistance. Just reading the question. Does the program allow one small business to be the mentor with another small business as the protege for purposes of receiving the FCL? So if your only reason for entering into a mentor protege is the FCL process, I would not put that in your mentor protege agreement. It's probably going to get rejected by SBA, because the idea is SBA wants the mentor protege program to be broad assistance. What the SBA always says is it's not business development assistance, it's assistance to develop your business. So it's not just marketing, it's not just getting contracts, it's not forming JVs, it's not winning work. It's about growing the company and teaching the company how to stand on its own, the protege. But you can be a small business and mentor another small business. So there is no restriction on that. And so if you're forming that type of JV relationship with two small businesses, part of the assistance you provide can be helping them get a clearance. It just can't be the sole or sort of main reason. You need to talk about a lot of other things in there, the financial, the management assistant, things of that nature. But then once you have that, then you can work together to get either your JV sponsored or get your protege sponsored, as we talked about earlier. That's perfectly fine. And sort of a follow on there is this allowable if the small business is required to be registered with the SBA in advance? So nowadays, this I guess is an important point too. The SBA side of JVs, you only have to get the JV approved before award if it's an 8A sole source contract. There is no requirement anymore that the JV be approved if it's not an 8A sole source. The old rule was that any 8A contract, including 8A competitive, had to be approved prior to award, whereas everything else, small business, SDB, OSB, HubZone, WOSB, none of those JVs had to be approved ever at all. SBA has expanded that to say 8A JVs don't have to be approved either, but they're all subject to size protests. So if you don't get the JV approved, you can get protested. And if you're protested and the JV is deficient for one reason or another, you can lose the contract award. What's also interesting there is whenever you have these contracts that, let's say it's an 8A competitive, a lot of agencies, though, haven't completely caught up with the rule that they no longer have to be approved. So they are still requiring approval. And if you don't protest that and you don't get approval, even if you don't get approval because SBA says to you, we're not approving these anymore, why would we do this? You can lose that contract. So if the requirement is in the RFP that it needs approval, or similarly, if there's a requirement in the RFP that your JV or prime contractor needs to have an FCL prior to bidding, you can challenge that, because there's case law that says you need to have the clearance at the time of award or before, even later in theory, before performance using cleared information or classified information starts. So in some cases, you can challenge that as being an unduly restrictive requirement. That being said, whether something is unduly restrictive of competition is up to the agency, and there's a lot of deference given to the agencies. So if there's something where this is a procurement that's going to start immediately on day one, they're awarding this to you at 5 p.m. on Friday, and they need boots on the ground Saturday morning, right? Or something like that, that has cleared people. So they're saying, no, you have to have the FCL right now. We can't wait. If you don't have it, we're kicking you out because of some critical reason. Then it's possible that's not unduly restricted. It's possible that you could protest that and lose, because the agency would say, no, this is why. And GAO or the Court of Federal Claims could say, oh, we understand. That is a good reason why you would need the FCL immediately right out of the gate. So while you could challenge that kind of thing, it's not always guaranteed to win if the agency has a really good reason for it. Let's see some of the other questions in here. What if we requested information about investments in marijuana but didn't proceed after information was received? So yeah, going back to that issue, if you're looking into marijuana investments but didn't actually invest, it shouldn't be a problem. It's only if you actually have investments. And also there's questions, what could a spouse do it? If the spouse has no involvement at all, or kids or things, and probably, but this is a pretty new area, as you might expect, and we don't have a lot of clear guidance on these things yet. Okay, another question. We had a company who sponsored a TSI and interim and is cleared for some reason. The contract got on hold. Since last January, we didn't hear an update on the clearance. Any advice on you to get evidence further? So it's possible that because the contract is on hold, that DCSA is sitting on it because they don't think you have a need. So whoever you were working with GCSA or whoever did the sponsorship, like if you were getting a subcontract, let's say, the prime contractor should follow up on that because you can't do the work without it. If your sponsorship was merely because of this potential contract, it's probably going to get held up until that potential contract starts to move forward. And if the client, or the contract, or the agency rather, canceled the RFP, you might have to go through the whole process again. So I think it's worth whoever was sponsoring the GD254, whoever drafted it or held it, to talk to them and see if they can put you in touch with, or go get in touch with themselves, whoever it is at DCSA that they're working with, probably their rep, and kind of push through that. Let's see. We've been a cleared facility for years. I currently have one client that did not issue a DD254 with the contract. Should we push her? Yeah, so if you're doing cleared work and you don't have a DD254 on file for the contract, but you have an Fcl, and that's your main basis for holding your facility clearance, I would push them to get the DD254 processed, because without that, there could be a potential for DCSA to question your need, and if they don't have the DD254 with all the supporting information, they might cancel your clearance, which would obviously not be good. What if the minority member has the Fcl and the lead member does not? I think I talked through that already. Have you ever known DCSA to accept anything other than the JV itself to be cleared? No. So if the JV is going to be the prime contractor, I don't know of any instance where DCSA allowed the members to have clearances, but not the joint venture. That's the exact scenario that SBA was trying to push into place. But because of the DoD DCSA guidance on that point, I don't think DCSA is going to process things the way SBA wants it to. That's just what I've heard. I haven't tried to push through one yet, just because the rule's so new. I could talk to a few people in my office and see the colleagues who did that protest. Maybe they were in the process of trying to push it through, but I'm not sure. Let's see. Fcls are done by the cage code of the awardee on all max awarded to JVs. The JV itself is cage code, auto-populates. You can't change the cage code. It doesn't matter if the Fcl is ancillary. Right. So this person is raising a key issue, right? With SBA issued a rule, right? And DoD and DCSA are like, well, first of all, I'm not sure if you have authority to do it. I'm not sure how this is even going to work. And one of the issues that was raised here, it's a very good point, is that you can't change the cage code on an order. And if the Fcl is ancillary or not, the Fcl has to be the company who gets the contract. So if you're saying, well, look, the JV doesn't have to have a clearance and the majority member doesn't have to have a clearance under SBA's rule, if the cleared work is ancillary, only the mentor or the minority member has to have the clearance. Well, the fact of the matter is the software doesn't let you do that. And that's part of the issue with some of these new rules. I've seen it a million times because SBA issues rules pretty rapidly, which is great, good for them. They're kind of trying to keep up with the process, and it's been really helpful to a lot of small businesses. But sometimes you run into these problems because SAM doesn't let you do it, or various other databases doesn't let you do it. When you update information in NIST or something like that for when you're working with DCSA, it doesn't let you do it. So there's various issues where the software platforms almost have to be modified to catch up with the SBA rules. And at this point, DoD and DCSA is not even sure what they're going to do with it. So it's highly unlikely that various software systems are going to be updated to deal with it. And if it's not in the software systems, sometimes you'll be dealing with people, let's say DCSA or anyone else, and they'll just say, I don't know how to do this. Even if I thought and the higher ups told me I could start changing the way I'm operating, this computer program won't even let me input the information appropriately. So I think that's part of the issue that DoD and DCSA are also working through is how do we implement this, not on a legal level, but on a practical level. And I think that's going to take some time. Let's see. Yeah, so then there's a site about a GAO case saying the Fcl is required. If it's required by the offer, you can lose. That's a good example of where what I was saying is you can challenge it in theory and say that this is unduly restrictive of competition. But in a lot of cases, when you're dealing with clearances, GAO, the Court of Federal Claims, they're going to defer to the agency and say, well, this is security clearances. I can't get involved in that. If you're challenging anything with security clearances or speed of material getting to the warfighter or something like that, I highly recommend you go to the Court of Federal Claims, not GAO. GAO is always going to defer to the agency. More and more and more, they're getting worse, in my opinion. So if you're going to challenge stuff like that, you have to go to the Court of Federal Claims. But again, it's not like you're going to win there. You just there's more of a chance to have a critical eye. But at the same time, it can be really difficult. My subcontractor on a bid of a pending award that requires a TS clearance. Upon contract award, how long can the sponsorship take? That's a good question. With some of the big guys, I've seen them push it through very quickly. I think maybe a few weeks. On other cases, though, like the example that was cited in one of the questions earlier, because the contract might have been sitting, it's taken, I think that person almost a year. So there is no time frame for how quickly these things have to get processed. Another thing I'll note, and we're kind of running out of time, is that I had some of these common questions down here on a few slides, but I wanted to run
If
through.
you're going through the questions, they're not going to stop, Si. They keep on coming.
I know. I'll follow up too with people, I promise. But the other thing I get a lot of questions on dealing with M&A activity is a lot of people try, and I want to touch on this. A lot of people say, well, I don't have a clearance. I'm going to buy a company that has a clearance, and then I'll have the clearance. It doesn't work like that. You can't acquire a company and then have a facility clearance. What happens is if you acquire the company and hold them as a subsidiary, that company doesn't automatically lose its clearance, but you're going to have to keep those people on board. So your key management personnel, your FSOs, all that are probably going to have to stay employed after you bought the company until the parent company gets cleared. Or you have to put those exclusion resolutions in place so that you, the person who just bought and controls this company and maybe spent millions of dollars buying this company, maybe tens of millions, maybe more, you can't even have control. If you don't have a personal security clearance, you got to wait till you get that. And then you can't control through your company. You got to be on the board of that subsidiary, and only then can you have control, because your company that doesn't have an Fcl is still going to have to be firewalled. So they can't be involved. If you buy another company and you merge it into yourself, that Fcl most likely is going to go away. And you actually lost it. You had the opposite impact. And then you're going to have to go through the whole process again with you and the new people, which can be difficult. So what we usually recommend is keep everything in place in that company you bought. And if you need cleared work, run it through there. If you can't because you're an 8A or woman-owned or service-able vet or something where it has to have direct ownership, which you could, this doesn't work for 8A, unfortunately, but for some of the other ones, what you could do is what they call a reverse merger, where your company merges into the company you just bought, not the other way around. They could, in theory, keep the Fcl. You would still have to be excluded, and so would all your former officers, all your board members, everyone who doesn't have a PCL until you get the PCL. Then you can slowly start to replace people. So that's one thing I see happen all the time, or a question that comes up all the time that I wanted to hit on before we.
I'm sorry, I moved back because somebody wants something on slide 15. So I figured I'd bring that up while you're talking.
Okay. And I know it's 1 o'clock. I know there's a lot of information, a lot of questions. I can go through and try to answer some questions. I guess really quickly, there's one here on, can a JV get a GSA schedule based on experience? Generally, the JV has to have its own. You have to get its own schedule, and you have to. The JV itself has to have all those, commercial contracts and everything. Not the members, except Schedule 70. There's a pilot program for Schedule 70 that allows you to get the JV on a schedule just with the experience and everything of the members, but no other schedules that I don't think that's been expanded yet. Let's see.
So were there any other slides that you planned on getting through quickly, or were we to the end already?
I think most of the rest of the ones were questions that people could kind of look through.
Okay. So I'm putting up Sai's contact information up while he's going through the questions. We highly recommend you work with PilieroMazza, work with Sai, an awesome company law firm to work with, especially in government contracting. Hands down, we wouldn't recommend anyone other than them. So definitely reach out to Sai and have your issues resolved by them.
Yeah, another question here. Usually the JV facility address is the same as a protege. If the small managing member has an FCL, can the protege sponsor the JV for the FCL if the protege doesn't have a prime contract? You could, but the DD 254 would have to be based on the whole basis for the sponsorship. It'd likely have to be the pending contract. So I would work through your DCSA rep again. I've done this before, to talk to your DCSA rep about, or I've seen it happen before, about the process of, look, we have this pending contract. We know it's going to be awarded. We need the JV to be awarded. We have it right now. We don't have any pending contracts, but this one contract we're going after, we have a good likelihood of success and things like that. We need the JV. Can we sponsor the JV and have it sort of interim pending the award? I've seen that happen before. So it is possible to do that. So, yeah, people are raising that there is no Schedule 70 anymore. That's true. There is no Schedule 70. It's all been consolidated. But I believe the pilot program is still running. I'm not 100% sure on that. I usually use another individual to get people on the schedule, because as attorneys who do bid protests, we're not allowed to help people with competitive decision making under the GAO rules. So because of that, I usually don't get close to those issues. And when you're dealing with getting on the schedule or proposal preparation stuff, I'm talking to Reena, I'm talking to people who help people get on schedules, and they deal with those things. So I believe the pilot program, though, is still in place, even though the consolidated schedules have taken over. But I'm not 100% sure on the logistics. So,
all right. Well,
I guess I'll go through some of the other questions. I can get back to people online or by email. If people have questions, I'm happy to address them.
Yeah, we'll share these questions with you, Sai, and the contact information if you'd like to get in touch with them directly and answer some of their questions. We'd really appreciate it. Again, Sai, thank you as always for your time, and you always come so full of information. It's mind-boggling. Thank you. Thank you for that. Appreciate all the participants being active, all the questions. We'll try and get these slides out to you sooner. Typically, the chamber likes to get the slides to their members first, but I know there's a lot of information here that we didn't cover, so we'll get these out to registrants and participants as quickly as we can. Thank you all again for participating. We do have another webinar coming up tomorrow. If you are interested in doing business with the DoD, we have all about how to do business with the DoD and some of their upcoming year-end stuff, dollars coming out. So you might be interested in registering for that as well. So thank you, Sai, and look forward to our future webinars together.
Yeah, thank you.
All right, take care. Bye-bye.
Bye, everyone.